Good evening. Thank you all for coming. I'm very grateful. This is a terrific turnout, but I think it's largely attributable to the topic and to the wit and wisdom of our speaker tonight. I'm Teresa Collette. I'm a law professor here at the University of St. Thomas. I am the director of the Prolife Center. We have a particular perspective, as one might imagine, with the name of that center. But there are lots of issues that involve pro-life, and my colleague Tom Berg, who is the Oberstar Professor of Law and Public Policy, teaches intellectual property as well as constitutional law, and recently chaired a meeting over in England regarding this very question that tries to puzzle through the benefits of allowing some sort of commercial protection for some of the scientific discoveries that are extremely exciting versus the commercialization of the human person, which is deeply concerning to all of us, regardless of how you stand on other issues that are identified as pro-life. So Professor Berg will be addressing sort of both sides of the topic as he described the position, because he said, you know, there are lots of things I'm not really sure where I come out. So that should be a very engaging lecture. Before we start that, I wanted to just thank the Students for Life for assisting this evening and co-sponsoring. They are the undergraduate organization, and if you're interested in learning more about them, they have a representative at the table with the cheesecake and the candy. You are welcome to both, and you do not have to give me your email for either. But without further ado, Professor Tom Berg on Patents on Human Life, Legal and Moral Questions. Thank you.
There we go. Thank you, Teresa. I'm really happy to be here. I'm happy to be speaking for the Pro-Life Center at St. Thomas because it's a great witness as an institution on the issues that we think of as sort of commonly pro-life issues. But Teresa and the other leaders of the center have always been folks who have understood pro-life in a holistic way and in a way that raises lots of questions and challenges for us across areas of society and across topics. So I'm really glad to be able to talk about this topic tonight, and thank you for inviting me, and thank you for coming. So before I get started on this topic, I would like to know who I'm speaking to. So how many of you are scientists, students or faculty? Okay, so we have one scientist in the room. Great. I don't count as a scientist, not at all. How many of you are in theology or Catholic studies or one of those kinds of fields? Okay, so quite a few of those. So it's theologians. I'm not a theologian either. And how many of you have a connection to the law school? Okay, great. And then how many of you are just lifelong learners across all fields? Everybody will raise your hand for that, but great. Okay, that's very helpful. I'm a lawyer. I'm not a geneticist. If there were, as our scientist, are you a geneticist? Okay, there are no geneticists. I was going to start off by asking for forgiveness in anticipation tonight for anything that I said wrong about genetics, which I'm almost certainly going to get something wrong in talking about genetics. But we'll soldier on here on this really important topic. So I'm going to begin 20 years ago, in May 1995, in the National Press Club in Washington, D.C. If you hear on NPR during the lunch hour, often they have a talk by somebody given at the National Press Club. It's the place where big ideas are floated, press conferences happen, the reporters report them, and then we all hear about it on the evening news. And there was a press conference held at the National Press Club in May 1995. And it was held by, okay, let's see here. Why is this is frozen up. Maybe I can bring the mouse up here and see if that does it. Sorry, this worked about 5 minutes ago. Okay, there we go. Thanks, Teresa. It was held by a group of religious leaders of different faiths, different Christian denominations and different faiths. It included bishops. There were a lot of clerical collars there, but there were Jewish clergy and Muslim clergy as well. And they were announcing something called the Joint Appeal on Human Gene Patenting. And they got a big turnout of reporters for the press conference, and it made the front page of the New York Times the next day. And their joint appeal was an appeal to Congress and to the United States government to stop issuing patents on human genes. And the joint appeal was actually a very short document. Most of it is quoted up here on this slide. And there it is. You can read it. We, the undersigned religious leaders, oppose the patenting of human and animal life forms. This was a few years after the U.S. Patent Office, which gives patents on technology, had begun to allow patents on the human genome, and it had also begun to allow patents on certain animals, including a mouse genetically engineered to be susceptible to cancer, especially susceptible to cancer for research purposes. The purpose of this appeal then was to criticize this and call upon the government to stop giving patents on this. We are disturbed by the Patent Office's recent decision to patent human body parts and several genetically engineered animals. We believe that humans and animals are creations of God, not of human beings, and as such should not be patented as human inventions. There were 185 signatories to this appeal. They came from 80 different religious groups. They announced a nationwide education campaign to educate the public on the dangers of commercializing the human genome. They made the front page of the New York Times and other papers. Nothing ever materialized from it. It was a great start and then a fizzle. The education campaign never materialized. Today, 30 years later, if you Google search for the full text of the joint appeal to stop human gene patenting, you get a grand total of 7 hits. What happened in those 30 years? 20 years, sorry. Where did this vigorous campaign go, seemingly vigorous campaign? Fast forward 20 years later, we're in 2015. I got interested in this topic. I'm not a geneticist, not a scientist. I'm a lawyer. I teach intellectual property at St. Thomas. I'm also a student of law and religion, and I got interested in the ways in which religious thought, Catholic and other religious thought, might affect or give insight in our understanding of the intellectual property laws. These are the patent and copyright laws that have become so central to the functioning of our economy. We live in a high-tech society, we live in a high-tech age, and patents on technology and copyrights on creative work and digital work are really central to the functioning of our economy. They also raise important moral questions across the whole range of intellectual property questions. You may have followed over the years occasionally the questions about the availability of medicines for AIDS and malaria in sub-Saharan Africa and other poor parts of the world. That's a question about whether patents on medicines are going to produce more medicines that will be provided to people who desperately need them, or will patents raise the price of medicines and make it impossible for people to afford them? These are central sort of moral and social questions, and human gene patenting is certainly one of them as well. So I got involved in this with an institute at Cambridge, and I did it on behalf of the Murphy Institute here at St. Thomas, the Murphy Institute for Catholic thought, law, and public policy. And we put together a conference a few weeks ago in Cambridge investigating some of these questions. The title, as you can see there from the beautiful picture of Cambridge University, Patents on Life Through the Lenses of Law, Religious Faith, and Social Justice. We had speakers including legal scholars, practicing lawyers, bioethicists, theologians, patent judges from the courts in Europe, and officials from the Vatican. It was a really eclectic crowd, people who don't usually mix. It was great to see Archbishop Tomasi, who is the Vatican's ambassador to Geneva, talking with the General Counsel of Syngenta, the agricultural bio firm that has its seed operations here in Minnetonka, and an English barrister. All these three people engaged in conversation. And so I'll try to bring in tonight some of the things that we learned from that conference. So I'm going to talk about, I'm going to do this in 3 stages. First of all, Genetic Engineering 101 and a Supreme Court decision called Myriad Technologies on the patenting of human genes. And then we'll talk about patent law as a background and how the Supreme Court decided that case. And then we'll talk about some of the moral issues involving patents on the human genome. So here are some developments. In 1980, the Supreme Court of the United States, in a case called Chakrabarti, named after the scientist who created the bacterium in question in this case, upheld a patent issued by our government on a genetically engineered bacterium that was engineered to be able to soak up oil to clean up oil spills. And the Supreme Court said, you can get a patent on anything under the sun made by man. It's an extremely broad right that our government gives you. And we'll explain a little more just what a patent is. Patents on engineering living things, though, have raised concerns among people ever since it began to happen back in the 1960s and 1970s. And those concerns were raised to the Supreme Court. Are we entering into a Frankenstein era? Will we be genetically engineering human beings? Will we be creating monsters, half human, half animal? Where is this all going to go? And the Supreme Court said, not our problem. Those kinds of moral concerns about genetic engineering should be addressed to the Congress. If you think there are real problems with this, you can regulate this, but the legislature needs to act. And we're not going to interpret our existing laws to forbid the advance of technology unless Congress acts. In 1987, then, continuing on the slide there, the Patent Office issued a patent on the cancer mouse, the oncomouse, by researchers at Harvard University. They genetically engineered this mouse to be susceptible to cancer, and the Patent Office said that you can get a patent on that mouse and have the rights that come from holding a patent on that mouse. People have tried to get patents on other sorts of creatures. One of the strange ones was a 1997 application to get a patent on what's called a chimera, a combination of human and animal. In this case, what they claimed was that they had invented a combination, well, they wanted to have the patent on combining human beings with really a whole range of animals, from apes, monkeys, mice, pigs, goats. Okay? The Patent Office said no to that. We do not allow patents that are essentially on human beings. And that rule has continued and been adopted in legislation by the Congress in more recent years. But by 2013, 16 years later, there were thousands of patents given out by the government on various parts of the human genome, sequences on the human genome. It's estimated, for example, that as much as 40% of the human genome was covered by a patent by 2013. Until this case that we're going to talk about a lot, called Association for Molecular Pathology versus Myriad Genetics in 2013. All right, let's talk first about genetic technology, and then we'll talk about patents. We have two complicated subjects to wade through here in the talk tonight, so bear with me. The technology of genetic engineering that's involved in the Myriad case that I'm going to talk about rests on the basic technology of DNA and the artificial production of DNA. So here are descriptions of it from the Supreme Court decision itself, right? DNA, you understand, is a double-stranded molecule that winds around in a helix shape, and it has sets of substances called nucleotides that pair with each other. I'm not going to get into many of the details of this, but they ultimately produce amino acids, which in turn produce proteins, which are the building blocks of life. And in something of the same way that software in a computer generates something on the screen, scientists speak of DNA as coding for features of the human body. There are parts of the DNA that do that work of producing amino acids that produce particular proteins with particular features. And those are called exons. They're still in the first paragraph here. Nucleotides, the Supreme Court tells us, that do not code for amino acids are known as introns. In other words, there are parts of the DNA helix that don't do the work of producing genetic features. They do other kinds of work. They're important for other things, but they're not central to this, to the work of the DNA code. These things happen naturally in the body through processes called transcription and translation, paragraph number 2. They ultimately turn the double-stranded substance, DNA, into a single-stranded substance. There are a few steps, but a key step here is this thing called messenger RNA, which creates amino acids then through a second process called translation. Now, this happens naturally in the body, in the cells, but it also can be done artificially. Scientists can extract, as the Supreme Court says there in paragraph 3, DNA from cells. They use well-known laboratory methods, and those methods allow them to isolate parts of the DNA and study it, figure out what that produces. Does it produce, does it produce blonde hair? Does it produce certain other features? Does it produce disease? If there's a mutation on it, does it produce some kind of disease or other problems? And these are all of the marvelous ways in which DNA can be studied in order to do good things for people. It's also possible, the court tells us in the last paragraph, to create DNA synthetically through processes that are, again, well known in genetics. And in this case, you produce something that is the inverse of the messenger RNA strand that we've talked about. Essentially, it's a mirror of it and it's called complementary DNA. And it, like messenger RNA, does not have the intron parts. The introns, remember, are the parts of the DNA that don't produce proteins and don't produce genetic features, right? It excludes those. It includes only the exons, which are the part that do the work that the geneticist is interested in. And this synthetic DNA, end of the slide there, the last sentence, created in the laboratory is more stable than the messenger RNA, and that's what's known as cDNA. All right, so I've bolded and underlined 2 points there. The isolated sequence of DNA, genetic scientists want that. They want to be able to study it, but they also want to be able to produce the synthetic DNA called cDNA because it's more stable, and it also excludes the part that doesn't do what they're interested in, the introns, okay? What happened in this case that went to the Supreme Court? A company called Myriad Genetics identified the place on the human genome where breast cancer is caused, or the risk of breast cancer goes way up if there's a mutation in one of 2 genes, BRCA1 or BRCA2. Those mutations dramatically increase the risk of getting breast cancer for any woman, anywhere from 5 to 8 times the likelihood. Myriad wasn't the only one investigating this. Academic researchers were doing it, but Myriad went and got patents on this. And a patent, which we'll explain just a little more in a minute, means that Myriad would have the exclusive right to sell, make, or use the patented material. And that's what we'll come back to that in a second. Here's what they received patents on. They would have the exclusive right to use the isolated DNA sequences. That is the part of the gene just isolated, taken out, and viewed separately from its place in the genome. Number one, but also the cDNA sequences, which, remember, were synthetically produced and are more stable and eliminate the non-coding, the non-producing part of the gene. And they also so they would claim the exclusive right to use those 2 materials because they had patents on them. Right? They also claimed rights, exclusive rights patents on diagnostic tests for diagnosing the mutations in the gene that would cause breast cancer. They then, using their patent and their exclusive right, they sold and licensed tests for breast cancer mutations. Right? And when others offered testing, at least some others offered testing, Myriad wrote them nasty letters threatening to sue them for infringement of patents. They wrote to laboratories that were performing testing and doctors who referred patients for testing. They didn't do this in very many cases, but they did it in some cases. The doctors and the association that they belonged to jumped the gun to file suit in court and say, before you sue us, we're going to run into court and try to get the judge to say, your patent is not valid under the patent laws. So that sets up this case called Myriad, Association of Molecular Pathology versus Myriad. Okay, let's try to understand patent law briefly now. A patent, when you have a patent, you have an exclusive right for 20 years in the invention that you've made that is the subject of the patent. That can include a process, or it can include a product or a material. The way the law puts it is process manufacture or composition of matter, there in the first paragraph. The patent right is a right to exclude others from making, selling, or using that product or process. Okay? A key point, it does not ensure you the right to do it yourself. In other words, if there's another law that makes what you're doing illegal, the patent law doesn't override that law at all. It only gives you the right to stop others from doing it. Right? So there are other laws that can stop someone from doing immoral things with a patent, and that's an important point. I love Abraham Lincoln. I'm actually writing a play about Abraham Lincoln, so I quote Abraham Lincoln all the time. He was an amateur inventor himself and got several patents in the 1850s. Here's what he stated as the rationale for patent. By getting an exclusive right over the product, it increases your return, right? We know that you have the monopoly over something. You're going to be able to get more return from it. You're going to be able to charge more, right? And that adds the fuel of interest to the fire of genius, right? We encourage people, we incentivize them to produce things by giving them the exclusive right. But patent protection also has to strike a balance here. It encourages people to produce by giving them this exclusive right for 20 years, encourages them to innovate. But it has to not go so far that giving that monopoly cuts off further invention. And the Supreme Court in many cases has said this is a delicate balance. Patent law is all about striking that balance, because that same monopoly that increases the return to the patent holder increases the costs for others and prevents others from making free use of information. So where do we strike that balance? And in striking that balance, we can say that there are probably two attitudes towards patent law. One is kind of a skeptical attitude, and the other is a gung-ho, patents are great attitude. The first one says that patent law is a limited, instrumental grant of rights for the purpose of encouraging innovation and disseminating that innovation. And it should be expanded only cautiously. We give you a monopoly in something only enough to get you to innovate. And let's not do anything more than that, because that's going to raise the cost to everyone else. On the other hand, the gung-ho view of patents is that this is a property right. You have created something, you have invented something, and you should get full control over that. And then by contracting with people in market transactions, we can when you do that, we can ensure that if someone values your invention even more than you do, they'll buy it from you, right? And they'll be able to apply it better. They'll be able to commercialize it, so to speak, and that'll be great, right? Inventions will not only occur, but they'll also be commercialized in the most efficient way. Property rights are great. Contracts are great. The market works. That's the gung-ho view on patents. Which view controls may be highly relevant here. Is it a limited right, or do we take the gung-ho position? All right, there are requirements for patentability that balance these two goals of encouraging innovation but not cutting off further innovation too much. We've already suggested one here, and that is that it must be an invention. It must not be something occurring in nature. Okay? It must be a non-natural material or process. Second, it must be novel. Okay? You have to actually invent something new. It can't be something that's already been out there before the public when you filed your patent. It not only has to be new, but it has to be enough of an advance over the previous stuff that's out there to justify giving you this 20-year monopoly. And that term is it must be non-obvious. A really small advance that's just the obvious thing that you do next doesn't warrant getting the 20 years of patent protection and exclusivity. And finally, it must be useful, which means it must have a specific purpose. Basic research that's just kind of good, it'd be good to know this, it'd be good to know such and such, is not patentable unless you can explain some specific utility for it or usefulness. Right, we're going to spend most of the time talking about the first criterion up there, but the next three are also important. Let's talk about invention versus nature, non-natural versus natural. Do we have a clock here? Anywhere in the room? Okay, good. Here's the way the law states the issue about patenting of nature. Laws of nature, natural phenomena, and abstract ideas are not patentable. Manifestations of nature should be free to all men and reserved exclusively to none. Right? You can't patent what's out there in nature. You discover it, great, wonderful. You go off in the jungle and you spend 5 years going around the jungle and you find a new plant that has some medicinal purpose. You cannot get a patent on that plant because you didn't invent it. You just discovered it. The Supreme Court says it has a rationale for that rule as well. Nature is a basic tool for scientific and technological work. If we allowed patents on natural things, the grant of patents, second paragraph there, the court says, would tie up the use of those tools and thereby inhibit future innovation. Okay? You'd be landing in the second, you'd be overstepping the second side of the balance. You'd be interfering with later creation by giving too broad a right. Sometimes the court calls that preemption. We'd be preempting too many further inventions and innovations. On the other hand, virtually everything that's invented involves some use of a law of nature or some natural product. You use the features of some metal or some rock or some natural law or whatever to apply it in some way. So we've got to draw a line here. We've got to find the right balance again between invention and nature. Courts have different ways of saying that, but there's no absolutely clear line. All right, that's the issue in the case about the breast cancer gene. Myriad Genetics claimed a patent and exclusive right over two things: the sequence of the gene, basically taken out of the body and isolated, the part of the gene whose mutation causes breast cancer. It claimed that, an exclusive right on that, and it claimed an exclusive right over the synthetic version, right? The complementary DNA with the non-coding part excluded. And both of these are highly useful, right? To be able to take the gene sequence out and isolate it and study it is extremely useful. But they also need to be able to manipulate it. In order to come up with treatments, they want to be able to inject it back into cells. And therefore, this synthetic DNA that's stable, that you can work with, that is missing the parts that don't do the work that they want it to do, that's also hugely important. And Myriad claims an exclusive right in both. And the Supreme Court splits the difference. It said the isolated sequence of DNA that you've got a patent on, you've just taken that part of the gene out of the body and isolated it, and it's no different. You are trying to get an exclusive right over nature by doing that. But the synthetic stuff, the cDNA, is patentable. Right? That results, the court says, number 2 there, in an exons only molecule, right? Just the part that does the work we're concerned with that is not naturally occurring. And so it's a split decision. But it was a really important decision because it struck down some patents. This is, remember, 2013, the Supreme Court says this. The U.S. Patent Office for 25 years has been giving out exclusive rights in sequences of the human genome. And many people thought it was too late to turn back on that. The Supreme Court said, no, even after 25 years, if these things are invalid, if they are actual natural phenomena that Myriad has simply discovered and not invented, we're going to strike those down. Okay, what does this all mean? I'm going to run through this very quickly. The first thing I want to tell you is that's Justice Scalia there, right? You know Justice Scalia. You've probably seen him on TV or wherever. He wrote a concurrence in this decision in which he said, I agree with the court, but I don't think I really know what I'm talking about here with this technology, right? He says, here's the way he put it, right? The second sentence up there, I am unable to affirm the details of molecular biology on my own knowledge or even my own belief. So this is, a highly technical area. Now, there's a question whether the justices of the Supreme Court really fully understand it. But what did this decision mean? Because some of the patents were struck down, were invalidated as involving nature rather than invention, very soon after that, Myriad companies came in and offered testing at far lower than what Myriad had been offering. $2,200 versus $4,000, right? So you can see immediately the kind of thing that a patent may do. It may be great. It may have encouraged Myriad to do the work in the first place, and we need that work. But it also meant that insurance companies and the women who are paying the premiums and the employers paying the premiums had to pay $4,000 for a test rather than $2,200. There are various other consequences of Myriad. I'm going to leave this now because they get a little bit kind of above my pay grade, maybe above all of our pay grades here. So let's stick to the main points and now talk about the morality of all of this. So what is our discomfort with patenting the human genome? Where did that joint appeal come from when 185 religious leaders said, we call on you to stop doing this? There are two kinds of arguments, I think. We can classify them in two ways. Dignity-based arguments and consequentialist arguments. Those of you who take moral theology or ethics are probably use terms like that or similar kinds of terms. So what are the concerns? All right, first one, there are uses of genetic technology that are immoral or that would interfere with human dignity. And those ought not to be encouraged with a patent. Now, I guess we could debate some of these things, but starting to combine human beings 50-50 with pigs and producing chimeras, if you could do that, it would be immoral, or at least there are serious moral questions about that, and it would take a lot to overcome our qualms about diluting the concept of humanity and human dignity with that kind of creation. A more controversial one in our society is embryonic stem cell research, right? There are patents in the United States on embryonic stem cells as well as on the processes for generating them. Those processes result in the destruction of human embryos. And that, if you are committed to the proposition that a distinct protectable person begins at the moment of the fertilization of the egg by the sperm, then that is immoral. So the objection here is that the technology in question is immoral. And there's some room in patent law for making these kinds of arguments. But I'm going to explain a little bit more that room is pretty limited. If, for example, we allowed patents on an entire human being, the whole human genome of a person, you could imagine that giving the power to the patent owner to control, I don't even have to think it through, but maybe control a lot about individual human beings that had that gene pattern. That would be immoral. Right? We have a 13th Amendment to the Constitution that prohibits ownership of human beings. True ownership of the whole genome of a person might be akin to slavery. Okay, so what you can imagine then is that there are some kinds of inventions that are immoral. That's different, though, from a second kind of dignity-based objection. The second kind of dignity-based objection is not to the technology. It's to patenting the technology. Okay? Is there something wrong with patenting in general? And this is the language that the religious leaders used back in 1995. They talked about patents as involving the ownership of human beings. They, in some of the later writings that followed, spoke of patenting sequences of human genes as playing God. The joint appeal said, humans are creations of God, and as such they should not be patented as human inventions. Okay, this, when you think about the entire, control over the entire genome of a human being, that argument has a lot of force. But it's had very little effect on the gene patenting debate. And remember my question at the outset of this talk is, what happened to that prophetic, powerful appeal in 1995? It went nowhere, in part because these arguments here didn't succeed as to the patenting of sequences of the human genome. Why? It's too simplistic to say that every patent on genetic material involves the ownership of human beings. Right? So it's simplistic for several reasons that are, let's see, I haven't gone to it, sorry. Yeah. This slide here, it's simplistic for several reasons, the bullet points there towards the bottom of this slide. One is that patents on, at least on the synthetic DNA, don't involve the genes as they occur in the body. Right? This is a different material that's been altered to achieve a specific usefulness and utility. It's more stable. It's something that you can then use to do the things that you want to do with genetic engineering, to come up with gene therapy and so on for breast cancer. So that's one reason. It's not the actual, exactly the same thing as the human genome. It also involves just a short part of the genome. Typically a gene patent does, right? And with specific purposes and specific usefulness. It's more like, a lot of people have argued, more like an artificial hip or an artificial heart, right? Something created by human beings that's going to work in the body, yeah, and it's doing physiological functions in the body, but it is patentable. Artificial hearts, artificial hips, etc., have been patented for 50-odd years. And then remember, there's this third point about patents, and that is that they don't necessarily give you the right to use the thing that you have a patent on. If there's some moral objection to to the technology that you're going to use, then the law can bar that. separate from the patent law. And we do have other laws barring immoral uses of technology. So just speaking about these patents on the sequence of the genome as playing God is too simple. That argument did not persuade people, and I think it's probably right that it didn't persuade people in those terms. You need something more, you need to unpack the idea about playing God more. And here the notion of commodification is important. Professor Collette mentioned that word at the beginning. Will patents on genetic material or other parts of the body lead to things being for sale that shouldn't be for sale? Right? Commodification is something that runs throughout our lives, right? We pay for things, we sell things. When we go to a job and get paid for it, we sell our labor. That's a kind of commodification of ourselves, in a way, of our work. We put a price tag on it. There are lots of things that we put price tags on things throughout our lives. But there are also things that we don't put price tags on, right? Many things. The right to vote, the right to speak, many legal rights. We want to ensure those to everyone. The right to life, we don't put a price tag on. And it's quite right that we shouldn't put price tags on central features of human life that ought to be available to everyone, regardless of their ability to pay. So commodification can be a worry. If we see a steady march of money and payment and selling from areas where it didn't exist before into new areas, we have reasons to be concerned about that. Now, that doesn't mean that patents on sequences of genes are inherently wrong or inherently in conflict with human dignity. But it means that we should have some qualms. There could be lots of reasons why we'd be worried about it. It may be a slippery slope onto the buying and selling of other things. The more we ingrain in our minds the idea that everything can be owned, the more we may regret that down the line. Of course, we prohibit the sale of organs, of human organs. We allow voluntary donations, right? Why do we prohibit the sale of organs? Well, it would be a serious loss to you to lose an organ, right? And we worry that people will be pressured into doing that. We worry that when money comes in, it will move beyond the kind of voluntary act that is often, done for a family member or a close friend. That's a remarkable act of altruism, but when money comes in, it may change the whole relationship, and that the altruistic part and the relationship of the donor and the recipient may go away. Gene patents may raise some of the same kinds of issues. This is an area where we're at least worried about commodification. That concern, though, shades over into another one that the critics never raised. And this is where I'd fault them, one of the things that I'd fault them for, and a reason why they didn't succeed. And that is, they never tied their concerns about ownership and commodification and commercialization to real consequences for human beings. And there are a couple of consequences. Patents, again, can raise the cost. They can undercut and put up barriers to further work by other researchers and access to medicine for people with fewer resources. It's a worry that if more and more medicine becomes and medical technologies become produced out of commercial means, the price will go up, or the price will go up for beyond the ability of people to afford it. That is what the critics should have. They should have at least tied that into their criticism of patenting human genes. They never did. They just said, we're playing God, we're owning human beings, and that was too broad. It wasn't nuanced enough. It didn't show an understanding of precisely what a patent is, and as a result, it failed. It didn't convince anyone. How are we doing? We're probably well into the discussion time by now. Yeah, okay. So it turns out that Europe has a much more vigorous debate about the morality of patents than we do in the United States. And one of the things that came out of this conference was our understanding that, that the law in Europe provides much more room for moral objections to issuing patents, including on embryonic stem cells. The European law prohibits patents on embryonic stem cells, and the reason it prohibits them, according to the European Court of Justice, is because embryos are destroyed in the process. Right? It's actually a pro-life decision from moment of fertilization, right? Pro-life decision of the European Court of Justice interpreting a specific provision in European law. That's really quite striking, but it's very different from the United States. One of our speakers at the conference has written that in the United States, we tend to patent first and ask questions later. And that's the way it's mostly worked. The Supreme Court stepped in 25 years later and asked the question and struck them down. But we do things differently here. All right, I'm going to skip to the last slide here. And what lessons can we draw for how religious or pro-life groups should think about or express qualms about patents on human genes? First of all, we should applaud the Supreme Court for saying you can't patent a piece of nature like a sequence of the human genome. Right? That's very important to maintain that idea. Second, that doesn't mean we should condemn gene patents per se or attack them per se. Instead, should focus on a couple of things. The first one is, number 2 up there, preventing and limiting the harmful effects of particular technologies. Genetic discrimination. What about genetic manipulation that allows people to create super viruses that can be used for terrorism purposes? We need to worry about those things. That's not an attack on patents in general. That's an attack on the technology that the patent may support. But finally, we should have some concerns about patenting genetic material. But they shouldn't be put in this kind of broad statement of this is the ownership of life, right? Because patents are narrower and distinct in some way, in important ways, from the ownership of human life. Instead, what we need is a broader concern about the effect of patents in commodifying and introducing commercial elements and buying and selling in a new aspect of our life. And that includes being concerned about the cost of patents on research by others and on access by those in need. And unfortunately, the religious and pro-life groups that expressed qualms about patents never put it in those terms. They didn't focus on the costs to the poor. And if they want to express those qualms in the future, I think they'll need to do that. So I'll stop there and take any questions. I'm sorry I've gone over. Boy, there's a lot to cover, right? But thank you for listening, and any questions that anyone has, I'm happy to take them.
Tell us a little bit about more versus research, right? You say only research pay.
Yeah, yeah. So this is a case involving a man who was being treated at the University of California Hospital Medical Center for a kind of leukemia. It was a very rare kind, and his cells were of great interest to the doctors. They took a sample of his cells and created a line of cells out of it, which they got a patent on, and got significant commercial return from. They never told him that they were going to do that. They said they needed his line of cells to help him in his treatment. And he was understandably upset when he found that they were sort of getting a good deal of money on his cell line. And he sued not under patent law, but he sued under the ordinary state law of you took my property. Just the same thing, like if you came into my house and stole my computer, I would sue you. I might swear out a criminal complaint against you, but I could also sue you for what's called conversion. You converted my property to yourself. And he said the same thing. He brought the same kind of claim. The Supreme Court of California said, no, you don't have a right in these cells. The conversion claim does not proceed when you go to a doctor like this who's also doing research. Essentially, public policy requires that doctors who are engaged in research be able to make use of your cells. And so it's not a patent case as such, but it does indicate, again, the kind of problems that can come up when commercial incentives really get introduced into the medical field. I don't think we have to do away with patents in order to disapprove of and stop what happened in the Moore case. If nothing else, they didn't inform him of what they were doing. Right? A doctor has to get your consent before operating on you, but that also has to be informed consent. And these doctors did not tell him what they were planning to do with the cells, and may have actively misled him. So yes, I think Moore is an example of the kind of things that we might be worried about when commercial incentives enter into the field too much.
And in fact, the patient had moved from California after the initial treatment out of state, and they required him to come back to California simply for blood samples and other monitoring that could have easily been done in the same state, but they wanted to continue to test their experience. And so there was a very strong that what they had done needs to be punished.
Yeah. Yeah, and the rationale for the decision is a kind of public policy rationale that medical science will be advanced by doctors at a research hospital. They're at a research hospital, but doctors being able to use these lines. Okay, so we could say two things about that. Yes, it's true that research will be advanced and medical science will be advanced. And that's a good thing, and that's a reason why there ought to be patents on inventions that go along with human genes. But it doesn't mean that other laws go away, right? Again, a patent does not give you the right to violate other laws. It only gives you the right to stop others. It doesn't ensure that you're going to be able to do something with the patented item, and it certainly doesn't give you the right to mislead or steal from the patient in violation of all sorts of things, fiduciary duty or whatever. Yeah, that's true, but we don't, in medicine generally we say even if the operation is good for you, human dignity requires that you consent on an informed basis. So if that's missing, then it's a problem. Yeah, I mean, I guess you could, I suppose you could ask whether a part of the question was whether it was relevant or material to the treatment or his decision about the treatment that they would use the cells for commercial purposes. But he was, I think, understandably upset that he didn't know that they were going to do that. Yeah. I mean, the variation on this, a quite different variation, is the use of genetic material from indigenous people overseas, right? Companies come and there's a tribe that's got a certain disease that's unusual that we don't see in the West, but it tells us something about, something medically important. And we take genetic samples from them, or maybe it's from plants that they've used for medicinal purposes over the years. What obligation is there to compensate them for those, that use? And that's a significant question and dispute in international law that actually the Catholic Church has weighed in on. What Archbishop Tomasi and others that were at this conference from the Geneva staff, one of the things they do is take a position on sort of the social justice issues of using native remedies, indigenous technology, and first world companies, multinationals coming in and getting patents on those. What kind of benefits ought to be shared with the indigenous people themselves? So, same kind of question in a different context. Well, I think most of what I said here about raising questions about patents is the kind of thing that you direct to Congress. The court, and not to the courts, right? The decision from the Supreme Court is actually it's really short, and it's pretty, it's not very emotional. It doesn't bring in a lot of these social justice kind of questions about access to medicine and whether patents will increase the costs for the poor, right? The court just says, isolated genes are natural. You can't patent those. The cDNA, the synthetic DNA, that's different from what's in the body, and you can patent that. And that's it. And even the scientific question may be more complicated than that, which is why Justice Scalia said, I'm not sure I know what I'm saying here. But it certainly doesn't get into the moral questions. So even this decision that places a brake on gene patents doesn't do it on explicitly moral grounds. So I don't know. I don't know how much an appeal like that will work in the future. It is true, though, that there was relatively little from the religious community to the Supreme Court in the Myriad case. There was only one brief from a religious group in the Myriad case. And it was only one group on that brief, as the Southern Baptists. The rest of the religious community, these hundreds of clergy who were there in 1995 saying stop gene patenting, nowhere to be found. Nothing heard from on this vitally important case, right? And I'd suggest it's because they hadn't thought through the arguments very clearly. Their broad brush statements about playing God and owning human beings didn't stand up. And 20 years later, they didn't have something helpful to say to the court. And that's a real lesson, I think, for pro-life activism. It's a real lesson for religious activism, right? It's great to be prophetic. It's great to stand up and make broad statements about how something is wrong. But you also have to have your facts right, and you have to know the details of what you're saying. If you're going to talk about patents, you have to understand what a patent is. If you're going to talk about genetic technology, you're going to have to understand what's natural and what is the product of human invention, intervention, because it can be a very fine line to draw, and the critics didn't do that, I think. Yeah.
Is there any conversation about changing patent laws? On the one hand, inventions are happening, innovations are happening much quicker now than they were even 20 years ago. And Apple making the iPhone every 2 years is, or on the other hand, where you've got the copyright law in Disney, where it went from 12 years they started out with copyright paperwork, but then Disney started lodging now it's 50 years, so then they have 50 years with the new Cinderella movie to make sure that the copyrights are clean up so that the big companies can retain control of their products. Anything like that happening in the patent world?
So it does happen, but there are real barriers to it. Legislation in Congress is not decided by great arguments on one side or the other, right? It's decided by who's got political weight. And for the most part, I would say, at least under copyright law, in the last 20 years, the companies that produce the movies, the films, you're talking about Disney and so on, they've had more weight in Congress. And they've managed to achieve broader and broader copyright protection and to stop Congress from doing anything to cut back on that. So the copyright term has gotten longer and longer. An extra 20 years were added in 1998. And a lot of people said, why are you adding 20 years to the Copyright Act? And you're applying it to things that have already been created. That's not giving an incentive to anybody to create. The stuff is already created. Why are you doing that? Well, Mickey Mouse was about to fall into the public domain, and Disney had more pull with Congress than people on the other side. It's a little bit more evenly matched now that there are big throw-your-weight-around companies on the other side, too. There's Google, and there are companies now whose interest is in having open access to things on the internet rather than having content that's paid for. In the patent law, we did just amend the patent law 4 years ago in a pretty significant way, but it was mostly technical stuff. And I don't know, do you think Congress is going to be able to handle these deep moral issues about genetic engineering? They can't agree, they can't get a budget any year, right? How are they going to handle these things? And they haven't. The court has said, you want to do something about the problems of genetic engineering, go to Congress. Congress doesn't do much. And, that's a bit of an overstatement, but it doesn't do much.
Well, thank you.
Thank you.
I appreciate it very much.
I hope it was comprehensible. Yeah, it's a complicated area, but it's really important to our lives. So if you want to talk afterwards, I'll stick around for a little while.